The Subcommittee on Elections will come to order. I note that a quorum is present. Without objection, the chair may declare a recess at any time. Also, without objection, the meeting record will remain open for 5 legislative days, so members may submit any materials they wish to be included therein. Thank you to Ranking Member Sewell, members of the committee, and all of our witnesses for participating in today's hearing. It is a first principle for our country that every eligible voter, every American citizen who wants to vote, must have an opportunity to cast a ballot within the time and in the manner specified by law, and just as importantly, for that ballot to count according to law. According to our Constitution, the states have the primary authority in election administration. They have the responsibility to determine election laws and to administer federal elections. The role of Congress in elections is secondary, to provide oversight and to support the states in their efforts. Our hearing today will highlight how voters across the country are demanding reforms to ensure that every eligible American voter can be confident that they will have access to the ballot box and that their ballot will be counted according to established law. To most Americans, this is not difficult and it is not revolutionary. While some voices may claim that efforts to help voters have confidence in our election systems and outcomes restrict access to the ballot box, that simply isn't what most Americans believe, and it is certainly not the work of this committee. Most of us agree that our federal elections in each state and territory should be governed by a standard of rules that are in place before balloting starts, that are understandable to the average voter, and that provide protections to ensure all lawful ballots count, but no others. While there is no one-size-fits-all approach, efforts to boost voter confidence and improve voter integrity include working to bring trust to our elections by making the process easy to understand, bringing transparency through openness for election observers, public access to voting machine testing, and strong communication with the voting community, and helping to remedy weaknesses in the system by requiring voter identification, strong chain of custody requirements for all ballots, and continuously updating training for our neighbors who volunteer their time as poll workers. These sorts of reforms have been implemented in states like Georgia, which has seen incredible voter turnout as voters' confidence in the system has improved. In New York, voters rejected a number of elections-related ballot initiatives that would have weakened some protections. And in several states across the country, legislatures have made efforts to modernize their election systems to address voters' concerns and ensure the integrity of the process and the confidence of the public. It's important that we work together because if voters trust our election systems with tasks like ensuring all voting machines are working properly and that there is a sufficient number of ballots available, voters are more likely to have confidence in our elections and in our election results. I look forward to hearing from our key witnesses from states across the country as they share successes and provide insight into the ways voters in their states are following this framework to promote voter confidence. As the former chief elections official in Florida, I know firsthand the successes that led to our work in the elections field and what led to our success in election administration. Engaging directly with voters was one of them. Ultimately, when voters have confidence that their ballot will be counted, they vote. Our role as the Subcommittee on Elections is to examine areas of improvement in the election administration process and to empower states to make any necessary changes that will ensure every eligible vote counts. Thank you, and I yield to Ranking Member Sewell for the purpose of making an opening statement.
Good afternoon, and thank you, Chairwoman Lee, for welcoming us today. The topic of today's hearing is an important one, ensuring that every eligible American has the opportunity to vote. For far too long, that has not been the reality of our electoral process. Since the founding of our country, large segments of the American people have been intentionally excluded from being eligible to vote, and their access to the ballot box purposefully curtailed. Enslaved persons, indentured servants, Native Americans, and women were all denied the right to vote, and this is not in the distant past. The 19th Amendment guaranteeing women the right to vote was ratified in 1920. The 23rd Amendment allowing residents of the District of Columbia, the capital of the United States, to vote for president and vice president was passed in 1961. Poll taxes of any sort or taxes to vote were outlawed by the 24th Amendment in 1964. The voting age was lowered to 18 by the 26th Amendment in 1971, ensuring that the men and women serving in our military are able to participate in electing the leaders who would send them into harm's way. The Voting Rights Act, a law that addressed systemic discrimination and barriers in voting, was enacted in 1965, less than 60 years ago, and it was amended, expanded, and extended by Congress 5 times, in 1970, in 1975, in 1982, in 1992, and 2006, because barriers to ensuring every eligible American can cast ballots still exist. It's also worth noting that every congressional reauthorization of the VRA was signed by a Republican president. Voting rights and ensuring and expanding access to the franchise should not be partisan. As we approach the 10th anniversary of the Supreme Court's Shelby decision undermining the Voting Rights Act, we must recommit ourselves to the ideals that every American should have a voice in our democracy. We must celebrate increases in voter participation, not respond with restrictions on voter access. Additionally, overall voter turnout numbers in and of themselves do not tell the full story. Voter disparities by race continues to exist. You need only look below the surface to see a more fulsome picture. Many of the voting laws passed in the wake of the 2020 election go to the very heart of the integrity of our elections. Directly targeted methods voters of color used in 2020. Americans' confidence in election is eroded when their leaders falsely claim over and over again that an election was rigged or fraudulent. Rather than using lies and falsehoods to justify unnecessary voting restrictions, Congress should be focused on expanding access to the ballot and ensuring voters in every state have access to the franchise. The voters of Alabama and every other state should have access to every possible venue and avenue for casting a ballot, and should not have fewer options for voting simply because of where they live. Ensuring every eligible American can cast a ballot is a goal we should all strive for. It is the bedrock of our representative democracy. Congress must work to pass pro-voter, pro-democracy legislation and policies rather than using unproven claims of widespread fraud to roll back the access of many Americans that many Americans have fought so hard for. Many Americans like those in my district and in my hometown of Selma, Alabama, where John Lewis and so many others shed blood on a bridge in my hometown for the equal right of every American to vote. I look forward to hearing today's witnesses and the discussion to follow. Thank you, Chairwoman Lee, and I yield back the balance of my time.
Thank you, Ranking Member Sewell. For today's hearing, we will be joined by Representatives Nakima Williams, Chip Roy, and Claudia Tenney, and they have been waived on to the committee to participate in today's hearing. Without objection, all other members' opening statements will be made part of the hearing record if they are submitted to the committee clerk by 5 p.m. today. Pursuant to paragraph B of Committee Rule 6, the witnesses will please stand and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show the witnesses have answered in the affirmative, and you may now be seated. I will now introduce our witnesses. Our first witness, Ms. Lisa Dixon, serves as the Executive Director of the Lawyers Democracy Fund, a nonpartisan organization with a long history of advancing the role of ethics, integrity, and legal professionalism in the electoral process, including safeguarding the right of eligible voters to vote. Previously, Ms. Dixon practiced at Holtzman Vogel, where she specialized in tax-exempt organizations, campaign finance and election law, and lobbying compliance. Our next witness, Mr. Thor Hearn, has earned a national reputation for his work in complex federal and state litigation and appeals, especially matters involving property rights, constitutional law, and elections issues. Hearn is a nationally recognized authority in election law. Notably, he was an advisor to the Carter-Baker Commission on Federal Election Reform and has previously testified on election law matters before the U.S. Senate, the U.S. House of Representatives, and the U.S. Commission on Civil Rights, and the U.S. Election Assistance Commission. Our next witness, Mr. Joseph Burns, worked for Senator DeFrancisco, chairman of the New York Senate Judiciary Committee, for 4 years before serving as Deputy Director of Elections Operations at the New York State Board of Elections. In that role, Mr. Burns worked with county boards of elections, candidates, and party committees, and most importantly, he was involved in New York State's historic transition from lever to optical scan voting machines. Our next witness, former Georgia State Representative Scott Turner, is the executive director of the Eternal Vigilance Action and served as a representative in the Georgia House of Representatives from 2013 to 2021. While serving in the Georgia State Legislature, Turner focused on the issues of civil asset forfeiture, election administration, occupational licensing reform, agriculture, and the intersection of technology and public policy. And finally, Mr. Dual Ross is the Deputy Director of Litigation at the NAACP Legal Defense and Educational Fund, where he uses litigation and advocacy to ensure equal access to educational opportunities and the political process for people of color. We appreciate our witnesses for being here today, and we look forward to your testimony. Before we begin with your testimony, I would like to recognize Ranking Member Morelli, who wishes to make an opening statement.
Thank you, Chairman Lee, for yielding time to me, and thank you to the ranking member. Today's hearing reminds me of that well-worn Yogi Berra quote, "It's like deja vu all over again." Here we are again discussing the alleged lack of confidence in our elections. It's like we're watching a new streaming show called Election Denial, a show where the writers include at the outset a previously on election denial segment to discuss the crisis in elections confidence. But every week, it's the same scene. My Republican colleagues and friends crying lack of confidence, which they are squarely to blame for creating in the first place. Today's hearing is the third in a series entitled American Confidence in Elections, with a fourth scheduled next month, which has been convened to discuss this alleged lack of confidence in our elections. I, for one, do not understand the hearing series. The American people think many things, but they have not had their confidence in our elections shaken. Instead, they believe elections are secure. All told, this committee has held 6 elections-related hearings this year, either before the full committee or this subcommittee. And the lack of confidence theme continues to permeate my friends on the majority side's talking points. Indeed, the people fomenting this crisis in confidence are, first of all, former President Trump and his supporters in Congress. In truth, if anything, this, quote, crisis is a byproduct of the Republican Party's complicity in former President Trump's big lie. Instead of a lack of confidence in our elections, the American people are worried about backsliding towards autocracy. They are worried that the extreme wing of the Republican Party will continue to roll back voting rights, impose partisan election administration, and only accept electoral results when and if they win. This is not what our democracy should look like. These concerns are not fanciful. The repetition of lies and misinformation about our elections directly led to an insurrection on our Capitol and an attempt to stop the certification of a free, fair, and secure election. Nonpartisan experts agree the 2020 election was the most secure election in U.S. history. Every single Republican witness this Congress has answered when asked at the table, as all of our witnesses are, have asked that whether Joe Biden won the 2020 presidential election. They have all said yes. The continued failure to acknowledge or accept that fact by the majority actually undermines voter confidence and perpetuates dangerous behavior on the part of vigilante actors and those who seek to mine doubt in elections for their own profit. We know that the former president and his lawyers filed dozens of frivolous lawsuits that were ultimately thrown out of court for lack of merit, yet raised millions of dollars from donors and supposed legal funds to fight a, quote, stolen election, something the former president continues to say at rallies, rallies and public appearances. The former president went so far as asking repeatedly the Department of Homeland Security and the Department of Justice officials about seizing voting machines premised on the big lie, knowing that the Department of Homeland Security lacked the legal authority to do so. These actions actually undermine confidence in our elections. So here we are again. I'll keep showing up. I'll continue to listen for facts. I'll continue to ask questions, but I won't hold my breath for truth in this American Confidence in Elections hearing series. And that, my colleagues, is beyond troubling. Thank you, Madam Chair. I yield back.
Thank you, Mr. Morelli. Back to our witnesses, we appreciate you being here today. As a reminder, we have read your written statement and it will appear in full in the hearing record. Under Committee Rule 9, you are to limit your oral presentation to a brief summary of your written statement unless I extend this time period in consultation with Ranking Member Sewell. Please remember to press the button on the microphone in front of you so that it is on and the members can hear you when you are speaking. When you begin to speak, the light in front of you will turn green. After 4 minutes, it will turn yellow. When the light turns red, your 5 minutes has expired, and we would ask that you please wrap up. With that, I will now recognize Ms. Dixon for 5 minutes.
Thank you, Chairwoman Lee, Ranking Member Sewell, and members of the subcommittee for holding this hearing on ensuring that all eligible Americans can vote and be confident that their votes count according to law. We are currently facing a crisis of voter confidence. The peaceful transfer of power, which is so foundational to our system of government, rests upon voters trusting that their votes were counted and that the winner of the election actually won, even when the winner is not a voter's preferred candidate. Many polls over the past several years have shown a lack of confidence among voters, and the statistics are sobering. After the 2020 election, nearly 40% of voters doubted the election results. What is the solution? Restoring voters' trust in the election system and election processes at every step so that voters know that balloting, vote counting, and election results are accurate and that the winner was legitimately elected. Solutions to our crisis in voter confidence must be geared to both the actual integrity of the election and also the appearance of integrity of the election. The Constitution wisely reserved the power of election administration to the states in Article 1, Section 4. Conducting, managing, and regulating elections at the local level has many benefits, including boosting voter confidence. The vast majority of voters still trust that their own ballots were counted. Voter confidence decreases the farther away from the voters the control of the administration of an election lies. That is, voters still tend to trust their local election officials even when they do not trust the election results nationwide. State legislatures have and should continue to have the primary responsibility for setting the administrative rules for conducting our elections, with local election officials having primary responsibility for administering elections. The American Confidence in Elections Act operates within the federal government's limited purview to help increase Americans' confidence in election processes and outcomes without imposing on the state's primary constitutional duty and responsibility to establish rules of election administration. There are notes in my written testimony on ways the ACE Act does this. While the work of election administration is complex and challenging, it is vitally important because it protects one of our most precious constitutional rights. Significantly, the American people's confidence in the election process derives not only from the controlling laws and procedures, but also from local election officials' fair, competent, and honest implementation of those laws and procedures. States should follow 6 principles to restore voters' confidence, helping voters to have confidence that that only eligible voters are voting and their votes are being counted according to the rules governing the election. Number 1, the rules governing the election are established well ahead of the election and not changed close to it. This is a basic due process requirement, and it allows all stakeholders to know what the rules are and assists election administrators in running the election smoothly. Number 2, the rules governing the election are clear and designed to address many different situations and eventualities that may occur during the voting process. Number 3, the rules governing every aspect of the election system help ensure the fairness of the voting process while ensuring that eligible voters have an ample opportunity to vote and have their votes counted accurately. States have strengthened their election systems in the past couple years, and Here are a few examples. One popular reform is voter identification. Photo voter ID laws consistently show 75 to 80% support among the general public and majority support across all demographics. In the past few years, Missouri, Nebraska, Ohio, Wyoming, Montana, and Arkansas have all passed laws to strengthen their voter ID laws. And similarly, when voters vote outside the polls by absentee ballot, they should also have the protections of voters who voted at a polling place. Florida and Georgia have taken steps to strengthen their absentee ballot verification processes. The starting point for citizen trust in elections is accurate voter registration rolls. Florida and Mississippi, among other states, have recently taken steps to improve their list maintenance practices. And number 4, the rules and processes are super transparent and well publicized, and election officials educate the voters on the rules. Number 5, all guidance and regulations regarding and procedures for running the election are consistent with applicable federal and state statutes and are established according to the governing administrative procedural rules. Number 6, election officials follow the laws, regulations, rules, procedures, and guidance that govern the running of the election. Giving every eligible voter the opportunity to vote requires not only giving them the actual opportunity to vote, but also giving them the confidence to vote, knowing that their vote will be counted according to the law. Baseline requirements of due process, transparency, and good election administration should be uncontroversial. Thank you, and I'm happy to take questions.
I now recognize Mr. Hearn for 5 minutes.
There we go. Thank you, Chairwoman Lee and the Ranking Member Sewell and the members of this committee. I greatly appreciate the opportunity to appear and address this very important topic. I know we all care deeply about our elections. How our nation conducts our elections is really the bedrock of our constitutional republic. Without every eligible voter having the ability to cast a ballot and access to do so, and all citizens having confidence in the conduct and outcome of our elections, we the people would cease to govern our nation. Just yesterday, my 3rd granddaughter was born here in Washington, D.C., and that occasion caused me to remind myself that we in this generation, in the current era, have been blessed with an opportunity to live in the greatest, most free, and most prosperous nation in human history. This is a heritage that we have to steward for future generations. And having fair and honest elections is how we do that, how we steward this. I have been involved, and I provided the committee with a copy of my resume and bio that indicates I've been involved in election litigation and election law for now more than 30 years. It's been my experience, and I note that in my bio, that I have done so in a bipartisan way. I note particularly that the Attorney General of Virginia, Mr. Herring, appointed me to defend Virginia's voter ID law in court and in the Fourth Circuit. I note also that I had occasion to work with the local chapter of the NAACP in the redistricting of St. Louis County Council to assure that minority citizens had a right to participate equally in that election. And I report in the prepared statements that I provided, the comments that the NAACP Council provided about my work in that regard. Now, why do I mention that? I was counsel also, National Election Counsel to President Bush. I am myself a Republican. But I think that no matter how partisan our interests are, and there's nothing more quintessentially partisan than an election, the interest that we have in having a common outcome in the process of the election and having confidence in that and having equal access to participate in the election rises above our partisan interests. And I think that there should be tremendous ground for us to work together to find common ground to not only make sure everyone has access to a ballot that is eligible to cast a ballot, but also that everyone has confidence in the conduct of the election and it was fair and conducted according to the rule of law. In that regard, I had the opportunity to serve with President Carter and Secretary of State Jim Baker on the Carter-Baker Commission, and I brought a copy of that report with me today. I mention that because the Carter-Baker report was a high watermark of bipartisan election reform. It was an opportunity for Republicans and Democrats to come together and find some common ground on measures that would restore confidence and make sure there's access to the election process by all citizens, irregardless of their race, heritage, or gender. And that's what we did in the Carter-Baker Commission, and it has been reviewed by and relied upon by the United States Supreme Court in 2 cases, Marion County, which was the Indiana voter ID case. Twice or 3 times in the court's opinion, they cite the Carter-Baker recommendations for a strong bipartisan recommendation for how elections should be conducted. And then they also provide that there is a reason for, in the most recent Brnovich decision, again, the Supreme Court looked to the Carter-Baker Commission to try and provide a guide for, in that case, measures Arizona took to prevent ballot harvesting. And the recommendations of the Carter-Baker Commission were ones that the court looked to, that Arizona had adopted. And so I would commend to this committee's attention and the members of the committee the Carter-Baker Commission report as a good guide for bipartisan election reform. Thank you.
Thank you, Mr. Hearn. I now recognize Mr. Burns for 5 minutes.
Good afternoon, and thank you for this opportunity to speak to you today on a topic that I believe should concern people of all backgrounds and political persuasions, ensuring that Americans have confidence in our electoral system. As you know, I'm a lifelong New Yorker and former administrator at the New York State Board of Elections. Since leaving the State Board of Elections in 2015, I've had the great opportunity to represent candidates, party committees, and election commissioners throughout New York State and before courts at every level of our state court system. New York's elections are administered by bipartisan boards of elections in each of New York's 62 counties, plus 1 New York City Board of Elections, which is run by the 10 commissioners from the 5 boroughs that comprise the city of New York. This is all overseen by a state board of elections, which is led by 4 commissioners, 2 from each of the 2 major political parties. A bipartisan guarantee in election administration is mandated by Article 2, Section 8 of the New York State Constitution. While not perfect, this bipartisan structure, in my opinion, does a great deal to bolster the confidence of New Yorkers in their electoral system. Since 2019, due to one-party control of state government, New Yorkers have seen a number of major changes made to the state election law and in how elections are administered. 2 of the most notable changes were the establishment of a single combined federal and state primary conducted in June, and the establishment of early voting before all primary, special, and general elections. What might be more interesting, however, is what hasn't changed and what was rejected by the voters of New York in 2021. New Yorkers at the 2021 general election had the opportunity to vote on 3 amendments to the state constitution that would, as the amendment supporters would argue, expand voting rights and make it easier for New Yorkers to vote. Critics of those proposed amendments, like myself, saw them as a weakening of the common sense election integrity safeguards that have been enshrined in our state constitution, in some cases, for over a century. The state constitution specifically states under what narrowly defined circumstances the state legislature may allow for absentee voting. One of the defeated 2021 amendments would have eliminated this safeguard and enabled the state legislature to enact no-fault absentee voting. On Election Day 2021, the voters of New York rejected this amendment by over 300,000 votes. Opposition to this amendment didn't just come from where you would expect, the more rural and conservative parts of upstate New York. The amendment was defeated in Albany, Rockland, Onondaga, Monroe, and Erie counties, all large urban and suburban counties where enrolled Democrats outnumber enrolled Republicans. By an even greater margin, voters in 2021 rejected a constitutional amendment to allow the state legislature to enact same-day voter registration. The state constitution states that every citizen has a right to vote provided that they register at least 10 days prior to the election in which they will vote. The defeated amendment would have scrapped this very sensible election safeguard and allowed the state legislature to enact same-day voter registration. Like the no-fault absentee voting amendment, this amendment was defeated by the voters of New York. Like the no-fault absentee voting amendment, the same-day voter registration amendment was rejected in red as well as blue counties. Finally, voters in 2021 rejected an amendment that would weaken the anti-gerrymandering provisions of the state constitution. These anti-gerrymandering provisions, which were only approved by the voters in 2014, were originally backed by leaders of both major political parties and voters of all political persuasions. When the voters of New York had their say at the 2021 general election, the amendment was rejected by around 300,000 votes. New York voters let their voices be heard in 2021 when they rejected weakening the state constitution's election integrity protections. Maintaining the integrity of our elections and ensuring that voters have confidence in our system is not and should not be a partisan issue. Citizens deserve an electoral system that is free, fair, and honest. The results of the 2021 election in New York, I believe, demonstrate that voters across the political spectrum desire reasonable, common-sense safeguards to protect the integrity of our elections. Thank you again for inviting me today, and thank you for this great opportunity to speak with you on a topic of such great importance to our country.
Thank you, Mr. Burns. I now recognize Representative Turner for 5 minutes.
Thank you, Chairwoman Lee, Ranking Member Sewell, members of the committee. The greatest threat to our constitutional republic is misinformation and disinformation. This dubious pair will cause people to react in anger, cause acts of violence, and motivate people to take actions that are a danger to themselves, their communities, and the fabric of our nation. Faith in the results of elections is vitally key for the health of our republic, but more and more that faith is shaken by false allegations. The 2016 presidential election was marred by allegations of Russian hacking. And while evidence showed that the hacking was of email servers, by December of 2016, half of Democrat voters believed that Russians had changed vote tallies in favor of Donald Trump. That number would skyrocket to 67% by November of 2017 after a media barrage and many prominent leaders calling the presidency of Donald Trump illegitimate. That same poll showed 62% of Trump voters believed that millions of votes were cast illegally, although there was no widespread evidence that this was the case. When Stacey Abrams refused to concede the election to Brian Kemp in 2018, citing voter suppression, she filed a federal lawsuit that finally concluded this past October. In his decision, the judge wrote that Abrams and her group could not provide a single instance or direct evidence of a voter who was unable to vote, experienced longer wait times, or was confused about their voter registration status. Abrams' refusal in 2018 is when it became apparent to me as a state representative just how damaging misinformation and disinformation are to our country. Because when Abrams refused to concede, there was an immediate tone change among Republicans and Democrats who had worked together on elections issues in the Georgia General Assembly. What I would describe as a general collegiality became hyper-partisan and at times combative. Rhetoric designed to invoke racism, outrage, and emotional responses replaced thoughtful debate and analysis. And then 2020 came, and Donald Trump drove a Mack truck down the path that had been blazed by Hillary Clinton and Stacey Abrams before them, but they're all on the same path. My written testimony outlines how devastating all of these false attacks have been on voter confidence in Georgia, and further, why the state had a compelling interest to try to reassure all voters with the passage of SB 202 and other bills, and how opposition to these measures are a form of voter suppression in their own right. After the disaster of the 2020 primary, SB 202 was implemented prior to the 22 midterms. Its real impact, what actually happened, was a higher level of voter confidence from all walks of life. In fact, a post-election poll by the University of Georgia found that 96% of African Americans waited in line 30 minutes or less to cast their ballot in person. It went on to find 0 African American respondents to that poll said that they had a poor voter experience. Another key takeaway from the University of Georgia poll is that 89.7% of voters felt confident in the election process. Hillary Clinton Stacey Abrams, and Donald Trump, along with some members of the media, have all created doubt in the election process. In response to their claims, the Georgia General Assembly has worked to create a system that makes it easier to vote, have results that can be audited and verified, give voters options for their preferred method of voting, and build confidence using voter ID. They've made adjustments, including in SB 202, that have shortened lines and lowered absentee rejection rates. More voters are participating in early voting than ever before and taking advantage of all the various voting options Georgia has to offer. At each step of the way and with every improvement to the voting process, the Georgia General Assembly has had critics screaming at them that what they are doing is wrong, racist, and will hurt communities of various types. And just like the claims that Russia hacked the election and changed votes, or that Abrams lost because of voter suppression, or that the election was stolen, the data and evidence don't back up those claims. So if you were to ask me what Congress can do to help solve these problems, they can start leading by example. Every single member can make a choice today to not engage in over-the-top rhetoric to score some political points. Start acting like adults, start working together, and when states like Georgia try to clean up the mess, get out of their way. Or better yet, stand behind them and support what they're trying to do because their goals are noble. Thank you.
Thank you, Representative Turner. I now recognize Mr. Ross for 5 minutes.
Thank you. Thank you, Chairwoman Lee, Ranking Member Sewell, Chairman Stile, Ranking Member Morelli, and members of the subcommittee. I appreciate the opportunity to testify this afternoon. This Congress has the opportunity and obligation to strengthen our elections by finally making them equally accessible to Black voters and other voters of color. I'm an attorney at the NAACP Legal Defense and Educational Fund, an organization that was founded over 80 years ago by Justice Thurgood Marshall. And for 80 years, LDF has fought to secure, protect, and advance the voting rights of African Americans and other communities of color. Next month will mark the 10th anniversary of the Shelby County versus Holder ruling, in which the Supreme Court gutted the heart of the Voting Rights Act. Unfortunately, in the 10 years since Shelby County, a false narrative around stolen elections and voter fraud has fueled new state efforts to restrict the franchise of many vulnerable voters. Voters who overcame substantial obstacles in the 2020 elections in order for their voices to be heard. In these times of backlash, Black and brown Americans are facing one of the greatest assaults on our voting rights since the Jim Crow era. Today, I want to highlight 3 key elements of our current moment. First, Black voters continue to face a range of unnecessary and discriminatory obstacles that undermine their right to vote, from mass challenges and narrowing of voting options to closed polling places and voter intimidation through hypercriminalization of things like voter assistance laws. Black voters continue to often face a perilous pathway to the ballot. On top of this, in the most recent election, hundreds of thousands of Black Americans voted in districts that federal courts had ruled were illegally drawn to weaken their voices and to undermine the ability of voters of color to elect candidates of their choice who will represent their interests in this very body. Many of these obstacles to full participation by Black and brown communities are not accidental. Rather, they're targeted with, as courts have said, surgical precision to undermine the ways in which voters of color have been able to access the ballot. Some states have unfortunately taken this path of trying to cut access to those options that have allowed voters to have record turnout in 2020. Second, we're continuing to see troubling disparities in voter turnout by race that have persisted for a long time and have only grown in the 10 years since Shelby County. Robust overall turnout numbers have masked this disturbing trend, especially in places that were previously subject to pre-clearance before 2013. In Georgia, for example, disparities between white and Black voter turnout, both in the 2022 primary and general elections, were higher than at any point in the last decade. Third, courts have unfortunately eroded federal legal protections against voting discrimination. These protections are now dangerously thin, just as voters of color and other vulnerable voters need them the most. Unfortunately, Congress has failed to respond to this rollback of our voting rights. This current moment did not just emerge from ether or in a vacuum. Rather, we're here because of these false narratives have been fueled from a backlash against the growing multiracial nature of our democracy. The January 6th insurrection, the rash of anti-voter laws across states are two manifestations of this backlash. Our current moment is a part of a broader historical context. This story of our American democracy is one of progress, backlash, and retrenchment, at times by further progress, yet often delayed. This context makes it clear why Congress must act. Much like the bipartisan Congresses in the past in 1965 and 1970, 1975, 1982, and 2006 acted to pass and renew the protections of the Voting Rights Act, so must this Congress act to fulfill its responsibilities under the 14th and 15th Amendment. Pursuant to the Elections Clause, it's Congress that has the authority to enact minimum standards that can protect the rights of people to access the ballot, to strengthen voters' voices in choosing their president and congressional representatives in a way that ensures that it doesn't depend on where you live. Policies like same-day registration, robust early voting, accessible vote by mail can address voter turnout disparities to allow participation by all Americans. Black Americans have always fought to bring America closer to its highest ideals by focusing on their experiences while being mindful of both present, the moment, and the historical Congress. This Congress has clear guidance in order to fulfill its constitutional obligations. I look forward to working with you all and answering your questions. Thank you.
Thank you, Mr. Ross. Mr. Loudermilk will begin questions today, followed by the ranking member. We will then alternate between the parties. I now recognize Mr. Loudermilk for the purpose of questioning our witnesses.
Well, thank you, Madam Chair, and I thank all the witnesses for being here. And Mr. Turner, thank you for that very powerful opening statement. I think that is the crux of the things that we have to deal with, especially in this city. This is the, you may say, the Oz, the capital of misinformation and disinformation. I think you hit the nail on the head there. Something about the misinformation and disinformation that you spoke of, we hear a lot about it. And it's just not isolated to the states. In fact, President Biden, when he referred to SB 202, the Georgia election law that made it easier to vote and harder to cheat, he said that, if I remember correctly, that it was Jim Crow 2.0. Even the liberal media or left-leaning media here cited that as there was no truth to it whatsoever. How was that taken in Georgia? How devastating was that in our state?
Well, it obviously had an economic impact in Georgia because Major League Baseball, shortly after that, and at the encouragement of President Biden, removed the All-Star game from Atlanta and moved it to Denver. Thousands of average Georgians who were relying on that as an economic opportunity lost out as a result of something that ultimately turned out to be untrue based upon the data that we see today.
Which, as I mentioned, even the media here in Washington, D.C. identified it as being untrue, but it had devastating impact. Do you think that the election integrity reforms that were included in SB 202 helped or hurt voter confidence?
It absolutely has helped. The AJC, the Atlanta Journal-Constitution, recently posted a piece about voters returning to the polls. We saw a 740,000 voter drop-off in the runoff for David Perdue versus Ossoff and Warnock versus Kelly Loeffler. And many of those voters had said they'll never vote again. And as a result of SB 202, about a third of them are coming back, but not all of them, so there's still work to do.
Okay, I mean, it sounds like definitely going in the right direction.
Yes,
and serving with you in the General Assembly. I appreciate that. I know that you have a lot of integrity and honesty and adherence to the Constitution. So it sounds like SB 202 had no negative effect on voting in Georgia. And like the Democrats said it would. Now, you said something earlier that I think is very important, is the economic impact that it had on Georgia, and especially our new Truist Park with the Atlanta Braves, which were very proud to host the All-Star game. There were businesses, minority-owned businesses in that area that had spent a significant amount of money preparing for the All-Star game coming. I mean, I talked to business owners who were out, one of them was out $18,000 because he brought in extra food because of the increased business, which no one compensated them for once the All-Star game was removed. And considering the incredibly high voter turnout that you've mentioned, the positive aspect that Senate Bill 202 had, not just on Georgia, but confidence in Georgia's election, do you think that Major League Baseball Commissioner Bob Manfred owes Governor Kemp and the Georgia legislature and those small businesses in Georgia an apology for moving the 2021 All-Star Game out of Atlanta?
I absolutely do believe they owe the average Georgian an apology. Governor Kemp would be a start, but to those business owners, frankly. And if President Biden wanted to go back and look at the data and decide to change his mind, I would encourage him to call on Major League Baseball to bring an All-Star Game back so that those folks could be made whole. But his words right now have created economic damage to those folks.
And again, it's misinformation and disinformation with a political bias. And that's something that is going to take time to get over with, but I supported what you were doing in the legislature because I think it was going in the right direction, and we've proved that it did. And I'll just close with this question. How do you think that Senate Bill 202 will affect voter turnout in the 2024 presidential election?
I think the evidence is trending pretty positively in that direction, Congressman. The voting experience has been so drastically improved. The shorter lines, the additional options for early voting, people see it as easier to vote. That UGA poll that I mentioned, it said that 74% of the average voter in Georgia thought that SB 202 didn't have a change, and 14.5% said that it actually improved. So you're touching 90% of the folks who have looked at SB 202 as a very positive development.
All right. Thank you, Madam Chair. My time is expired, so I yield back.
Thank you. I now recognize Ms. Sewell for 5 minutes.
Thank you, Madam Chair. To Mr. Ross, I think that what we've heard reinforces what I was saying in my opening comments, that sometimes my colleagues seem to be inflating the turnout to mean that it's somehow the process is fair because the turnout, or even, I know in Alabama, my Secretary of State talked a lot about how his registration numbers went up while he was there. And so can you just clarify why it is that you have to look beyond the numbers to actually understand suppressive voter laws?
Thank you, Representative Sewell. So I think it's really important to not just look at turnout on the whole. So I think there are a couple of things that are important. One is that voters can still turn out to vote even if it's been made more difficult for people to vote. So if their polling places close, it does mean that a person who is poor or who may lack access to transportation may have to travel further, may have to pay more money in order to access their vote. So you have made it more difficult for them, even if they end up voting. And I think it's also important to note that it may be in places that turnout has gone up, but that racial disparities have either increased or stayed stubbornly the same because of these laws that have made it more difficult for African Americans and other people to vote. And so I think it's sort of a misnomer.
Many people came to vote because there was so much at stake in the Georgia election, senators, that despite suppressive voter laws, they came to vote. Is that what you're saying?
I think that's absolutely correct, Representative Sewell.
I know that, and you mentioned that we're approaching the 10th anniversary of the Shelby decision. How have the Supreme Court decisions in Shelby and Bronovich negatively impacted voters and shifted the burden from the states to the voters and advocates?
It used to be that under Section 5 of the Voting Rights Act and Section 4, which the Supreme Court invalidated in 2013, that states with a history of discrimination, including most of the South, parts of places like New York and California, had to seek permission from the courts before they could implement new voting laws. Unfortunately, what you've seen in the last 10 years is this sort of, the floodgates have opened to laws that have made it much more difficult for people to vote, and there's no check at the front end for stopping these discriminatory
Or federal
laws.
level, right? Because there's no Voting Rights Act.
Yes, Your Honor. It's true that
In
you
effect.
could, exactly. There's a Voting Rights Act that only allows you to challenge things after the fact. And so, sometimes we just simply don't know what the impact of these discriminatory restrictions on voting will be until they're litigated in court.
Absolutely. There's another Section 2 case pending before the Supreme Court, the Merrill versus Milligan case from my home state of Alabama, which I understand that you argued before the Supreme Court. I'm not asking you to speculate on the outcome, but I am asking you to talk a little bit about the underlying case and how that further erodes, or further shows the suppressive nature of some state actions.
Yes, so I'll talk a little bit about the Milligan case in which my clients challenge Alabama's racially discriminatory congressional electoral districts. There's a region of Alabama that Representative Sewell, you know very well, called the Black Belt, in which the state of Alabama has essentially—
I'm so honored to represent them since I grew up in the Black Belt, yes.
in which the state has essentially divided that community into 4 congressional districts, and when it's very possible to put it into 2 majority black districts. And 3 judges, 2 of whom were appointed by President Trump, unanimously said that this law violated Section 2 of the Voting Rights Act. Unfortunately, the Supreme Court stayed that ruling, and we're awaiting a decision any minute now. But I mentioned that in my opening, that both in Georgia, in Alabama, and Louisiana, federal courts had said that these kind of discriminatory maps had violated the Voting Rights Act, but they were stayed because of Supreme Court or other lower court actions.
We have seen a lot of state action around voter election laws all across the nation. I know Alabama switched its eligibility from showing, you could show 15 different things to show who you were in order to get your ballot, to now we only have 9. And one of them was a validly issued federal ID called a Social Security card. Last time I checked, there was no photo on it, but everybody has it. I think it's about voter access, am I right?
I think that's absolutely true, Representative Sewell, and I think what you've unfortunately seen in some states is cutting back on what kinds of IDs and things you can.
And so when states go amok, what do you think should happen? More federal oversight or some federal oversight?
I think it's really important to have the protections of the Voting Rights Act and the protections of things like that were in the Freedom to Vote Act.
Thank you so much. I ask unanimous consent to enter into the record 2 reports, each prepared by former chairs of this subcommittee, Marcia Fudge, G.K. Butterfield, documenting the state of voting in America and the disparate impact election administration policies have on communities of color. Thank you.
Seeing no objection, so ordered. They will be included as part of the record. At this time, I recognize Ms. Bice for 5 minutes.
Thank you, Madam Chair, and thank you for the witnesses for being here today. I hail from the great state of Oklahoma, and I believe that Oklahoma has some of, if not the best, voting election laws in the entire country. It is safe, it is secure. We find out our election results on election night, not days or weeks or even months, to my colleague from New York later. But I want to share one situation that happened during COVID, and that was that our election laws were challenged, and that is the absentee ballot process was challenged. A group of outside interests decided to sue to remove the notary requirement on an absentee ballot. It is the only way that you can verify an absentee ballot in Oklahoma. And although we thought it was sort of a strange idea that someone would think that it was invalid, in fact, the Supreme Court of the state of Oklahoma ruled that the statute was in the wrong title of law and struck down the notary requirement. This happened end of April, beginning of May of 2020. Had the legislature not been in session at that time, we are a citizen legislature and only meet 4 months out of the year, we would have found ourselves in a very difficult situation because there is no other way to verify an absentee ballot in Oklahoma. Anyone can request one, it's no fault, but thankfully we were able to rectify that by allowing individuals to send in a photocopy of their of their government-issued ID to verify that they are who they say they were. Otherwise, we would have been in a situation that many other states were in where our election laws were changed under judicial decree, and that is not what the Constitution calls for. Ms. Dixon, I want to start with you. In your view as the executive director of Lawyers Democracy Fund, which state implemented election reforms have actually increased voter confidence?
I think there are three main areas where state reforms increase voter confidence the most. That's in strengthening voter ID protections, improving list maintenance procedures, and improving transparency, which includes for things like prohibiting private funding or private influence in election offices and increasing observer access to every part of the election process.
This question is for any of the witnesses. Can you talk a little bit about addressing voter rolls? Because this seems to be a contentious issue. No one wants to address it. My home state's actually, I think, again, done a great job of trying to clean up the voter rolls, but it seems like a very difficult discussion in some states, and it shouldn't be. Does anybody want to talk a little bit about maybe states that are doing well and states that aren't? Mr. Turner.
Thank you. So Georgia has a challenge in keeping our voter rolls. Our election calendar prevents us from cleaning it during most of the election year, and that is something certainly Secretary Raffensperger has expressed as something that Congress can do to help Georgia keep a more accurate list, and we're completely and wholly dependent upon Congress action there.
For any of the witnesses, which election reform laws decrease voter confidence? Would you suggest ballot boxes?
I think laws that create a perception of careless handling of ballots, things like unmonitored drop boxes, no restrictions on who can handle an absentee ballot or return it for a voter. That kind of creates a perception in the public that ballots are just going everywhere. Also, mailing ballots to all registered voters without taking steps to clean the voter rolls first, as we saw in Nevada and DC in 2020.
And I would maybe just share that the absentee ballot process in Oklahoma, I learned a lot about chain of custody as I oversaw the election board, and I realized the importance of that because, to your point, making sure that you know exactly who has those ballots at any given time through the process is incredibly important to build confidence. Mr. Hearn?
And I would add and echo what Ms. Dixon said, but the Carter-Baker Commission made a recommendation about mail-in balloting and ballot harvesting, which are two things that do undermine confidence. They particularly said states should adopt a rule that only the voter, a voter's immediate family member, election officials, or a post office or courier service handle the ballot. Because when you have ballots that are basically just circulating freely within the electorate, no one can be certain who actually casts that ballot. And ballot drop boxes facilitate ballot harvesting, which again Arizona took, which the Brunovich case considered measures to prevent that. And I think those restore confidence to try to prevent that kind of ballot harvesting.
Thank you. My time has expired. Madam Chair, I yield back.
Thank you, Ms. Bice. I now recognize the ranking member, Mr. Morelli, for 5 minutes.
Thank you, Madam Chair. Let me start with you, Ms. Dixon, if I might. Did Joe Biden win the 2020 presidential election?
Yes.
Thank you. Mr. Hearn, did Joe Biden win the 2020 election?
Yeah, Joseph Biden is the President of the United States.
But that wasn't the question I asked. Did he win the election in
Yes, he's
2020?
president because
Mr. Burns, did Joe Biden win the 2020 election?
Yes.
Mr. Turner, did Joe Biden win the 2020 election?
Yes, and I'm confident that he won Georgia because of our auditing process.
Thank you, sir. Mr. Ross, did Joe Biden win the 2020 presidential election?
Yes.
Thank you. Let me, if I can, I apologize, I have too many tabs in my book. I wanted to ask, Mr. Hearn, I think in your testimony you stated that that every illegally cast ballot disenfranchised a citizen who cast a legal vote. And I've been listening closely not only to this hearing, but each of the ones we've had yet this year, and I have not heard any evidence that there's widespread fraud which would cost, or which would have caused disenfranchisement of voters. In fact, I think studies have shown actually the opposite. Illegally casting a ballot or committing acts of voter fraud are already crimes, are they not?
they are crimes, but they do happen. And to the point, it doesn't need to be widespread. We have elections that are decided by a very narrow margin. Going back to the 2000 Bush v. Gore election, several hundred votes could decide who's the president of the United States. So it needn't be a widespread vote fraud scheme. You can have any vote fraud that in many elections that are close could determine the outcome.
Well, it could. I would submit that while I think, given that there are literally hundreds of millions of ballots being cast, I suspect since humans are doing it, we're not perfect. There'll be some, but it's some that are perhaps mishandled, but illegally cast in a ballot, which was what you were referring to. It wasn't just mishandling or a mistake, which you could expect, but actually illegally casting ballots was what you were referring to, right?
And that's what the U.S. Supreme Court says, that
Yeah.
they said old-fashioned ballot box stuffing is one of the greatest ways that elections are corrupted. So did the Carter-Baker Commission with mail-in voting and absentee voting. We need to have common sense, fair protections against that potential for abuse.
Yeah, I appreciate that. I would say also that there was no evidence that that happened in 2020, despite the numerous claims of the former president and many supporters of his. I wanted to turn, Mr. Ross, I've heard the phrase "easy to vote, hard to cheat" many times now. And there's a claim that the goal of the laws that the majority seeks to pass in Congress are for that reason, to make it easier to vote, harder to cheat. So the laws passed, you obviously spent a lot of time observing this, but a lot of state legislatures across the country have, in the wake of the 2020 election, made changes. Have they made it easier to vote?
Often,
Yeah, I'm
Your
sorry,
Honor,
you, Mr.
excuse
Ross.
me. Often, Your Honor, they have not. What have you seen is that when you see states like Georgia, where black voters are turning out to vote in large numbers on certain days, like Sunday, you see cutbacks on particular days in which African Americans are more likely to vote. You see things like photo ID laws, which are structured in such a way that it's easier for white voters to have certain forms of ID. White voters are more likely to have something like a gun permit, so the state allows that. Black voters are more likely to have something like a student ID, so the state doesn't permit that. And so I think that we've seen this unfortunate backlash.
Yeah, so thank you for that. The impact of these laws, which you started to mention, doesn't make it easier for all voters to vote. It makes it, I don't even know if it makes it easier for any voters to vote, but it's certainly making it more difficult for many voters to vote. Isn't that the case?
That's absolutely right. What you're seeing is that it's making it harder for people to vote rather than easier in many states.
Thank you. I just wanted to make one other point, and I only have a few seconds left, but I just want to point, Ms. Dixon, in your testimony, you said, we're currently facing a crisis of voter confidence. It seems to me when the President of the United States states over and over, now 4 years later, that the election was stolen absent any information, that does not bolster voter confidence. Would you agree?
I would agree.
Yeah. Thank you. I'm out of time, but I yield back. Thank you.
Thank you, Mr. Morelli. Mr. Loudermilk, for what purpose do you seek recognition?
Madam Chair, I ask unanimous consent to enter into the record the University of Georgia School of Public and International Affairs survey of the 2022 election that was referenced by Mr. Turner in his opening statement.
Seeing no objection, it is so ordered and will be included as part of the record. I now recognize Mr. Chip Roy for 5 minutes for the purpose of questioning our witnesses.
Thank the gentlelady. I appreciate being waived on the committee and appreciate the witnesses being here. One of the issues we have in the state of Texas, and of course we do across the country, is dealing with ensuring that it is only citizens of the United States who are voting. And it's something that we believe needs to be addressed, and that we have an obligation here in Washington to ensure that states have the tools to be able to ensure that states can enforce the law in Texas, in our case, or any other state, to make sure that only American citizens are voting in our elections. Ms. Dixon, am I correct that currently the Department of Homeland Security, they have the authority to share data regarding naturalized citizens, but they're acting on this authority is left to the discretion of the DHS secretary. Does that sound right to you?
That's my understanding as well.
And that additionally, the Social Security Administration cannot share Social Security information with states for purposes of election integrity. Does that sound correct to you as well?
I believe so. I'm not positive.
So I've introduced legislation, the Protection of American Voters Act, which would try to fix this situation and allow states, in fact, it would require these agencies to work with states to share that information to ensure that states can have that information to validate and make sure that it is only, in fact, citizens who are voting in Texas. It would require DHS to provide that information without fee, by the way, to the states. Inquiring states, if those states are inquiring, it would give them that information from the SAVE system. And it would require the Social Security Administration to provide those inquiring states with Social Security information with confidentiality protections, of course, that provides for who is a citizen born in the United States. In your experience, Ms. Dixon, would that facilitate states' ability to ensure integrity of the elections and to follow through with the position that the vast majority of the American people, without exception, is not even a debatable stat, that the vast majority of the American people believe, shockingly, I mean, I'm just going to shock you, that American citizens should be the ones who are voting in our elections in the United States? Do you believe that that would facilitate that?
I believe so, yes.
Do you believe it's imperative that we, as a policy matter, work to ensure that it is American citizens who are voting in order to make sure that the integrity of our elections is protected?
Yes.
I would just say, Mr. Hearn, a quick question going back to Shelby. Now, I was a lawyer on the Senate Judiciary Committee in 2005 and 2006. As you might expect, that was a rather important time for the reconsideration of the Voting Rights Act. I was there for the many debates, debates among Democrats and Republicans in the United States Senate, here in the House as well, going through the data and the information. I was one of the lawyers putting together the record that the Supreme Court used in terms of looking at the data and looking at exactly what formed the Voting Rights Act's reauthorization of a formula, and just to make sure that the record is clear for all those saying that the Supreme Court got out of its lane to strike down Section 5 and that they acted imprudently in doing so. That in fact, the formula that was reauthorized in 2006, and I just want to make sure, Mr. Hearn, just make sure the record's clear, that that formula was from 1968, that formula dated back to, approximately 40 years prior at the time, now certainly 50 plus years prior, and that using that formula means that you were actually taking data and a formula that was not at all reflective of current times and what's going on with respect to jurisdictions across the United States. So for example, you would have jurisdictions, there were some in Florida, I remember, I don't have the map in front of me, but there were jurisdictions that were covered by the formula who had far more instances of voting irregularities and concerns and investigations by the Department of Justice than there were that were not covered by the, and vice versa, the formulas that did not match the actual data. So would you, Mr. Hearn, be able to expound on that, the extent to which we were using an outdated formula that did not reflect the actual reality of what's going on in the United States?
You're absolutely correct, Mr. Roy. The formula was what was the heart of the Shelby County challenge. And I think Chief Justice Roberts did a remarkable job, both during the oral argument of that case as well as in the opinion, of outlining how that formula from the early 60s was inapposite to the electoral conduct and the manner in which voters participated in elections in the current modern.
If I might just add for that, in the first decade after enactment, the AG objected to 14% of proposed voting changes. In the last decade before reauthorization, the AG objected to 0.16%. The fact is, the court righted a wrong. They fixed an error that this Congress did for purely political reasons, and therefore it is the better state of the law for having done so. I yield back.
Thank you, Mr. Roy. I now recognize Ms. Torres for 5 minutes.
Mr. Ross, several members of this committee also serve on the Appropriations Committee. This week, House Republicans canceled full committee appropriations markup meetings, putting the federal funding process on hold, period. We know that the bills this week, their bills, were considered as the easy bills, the easiest bills to pass, and were crafted to hide the biggest cuts to critical programs that serve as a lifeline for many people, not just in my district, but across the U.S. We also know that under the current Republican framework, across-the-board cuts to programs including in education, health, public safety, and our election system would likely reach at least 30%. When the majority release clear top-line funding limits, when they finally do it, for each of the subcommittees, we will see the full scope of the damage that they have in store for the American people. This year, we have heard from several witnesses in this committee about the importance of funding our elections or underfunding our elections, the damage that that causes. So how can election funding issues impact communities like the one that I represent, hardworking families, voters of color who don't live in the top zip codes in America and can have their driver, take them to the polls and maybe pay someone to stand in line for them?
I think, unfortunately, the fact that Congress has underfunded local elections has resulted in things that we're seeing, like longer lines in polling stations, making it harder for people to do things like register to vote. I think it's really important that Congress step up and provide funding for local elections to ensure that they're fully protected and accessible for everyone.
Thank you. The spread of election-related mis- and disinformation has fueled conspiracy theories that make it difficult for voters to receive accurate information about elections and their voting options. Conspiracy theories also make it harder for election officials to get accurate information to the public. I mean, we heard it right here when we talk about the Georgia election. If lack of ballots, if missing power cords that led to 3+ hours of wait time, purging over 53,000 voters, lack of training for the staff to help them understand the guidelines, and a candidate that had a direct conflict of interest as a Secretary of State running for governor. If that is not, interference and misuse of their power, I don't know what that is. But we do know that on January 6th, when insurrectionists terrorized the Capitol, which was incited by Donald Trump, failure to accept that he lost the election, when we were here trying to certify the election, those false allegations of widespread voter fraud led to this violent attack on this Capitol. Mr. Ross, in your testimony, you mentioned that you see the current wave of restrictive voting legislation in states as related to the January 6th insurrection, a connection that may or may not be so apparent. Can you explain that to us?
Yes, I think, unfortunately, what you're seeing is disinformation being around voter fraud, around stolen elections, and I think that is what's fueling these election changes. It's what's fueled the January 6th insurrection, and it's fueled what state legislators are responding to, this false narrative around stolen elections or voter fraud.
Thank you. In this committee, we've heard from our colleagues, that higher voter turnout numbers in recent election means that restrictive voting laws enacted by so many states are not, in fact, restrictive. Can you, Mr. Ross, share with us, how you view that as a truthful and unbiased statement?
Sure, I see I'm running out of time, but I know that a number of courts have found that these laws are in fact discriminatory. In Texas, in Georgia, in North Carolina, when voter ID laws were passed, they were struck down by federal courts.
Thank you, and I yield back.
Thank you. I now recognize Ms. Claudia Tenney for 5 minutes for the purpose of questioning our witnesses.
Thank you, Chairman Lee, and thank you to the Ranking Member Sewell. Great to see you today, and thank you to all the witnesses, and thank you for inviting me to participate. As the co-chair and founder of the House Election Integrity Caucus, the first of its kind, it is my honor to join you today, and confidence in our elections is at an all-time low. In the weeks leading up to the 2022 midterms, Pew Research polling found only 22% of voters believed the midterms would be administered very well, with only 11% of Republicans and 35% of Democrats agreeing. Only 26% of voters are very confident their vote will be counted when voting with absentee ballots or early voting. Importantly, this is not a partisan issue, and you can see the divide between upstate New York and New York City. Looking to the not-so-distant past in 2015 and 2016, it was Democrats, not Republicans, who were most skeptical of American elections. The Election Integrity Caucus, in our post-election autopsy report on the 2022 midterm elections, found that states that made pandemic-era election law changes permanent suffered from a severe lack of election integrity. For example, in California, legislators passed AB 37, making no-excuse balloting permanent. This led to delayed results and confusion. As a result, up to 16 congressional elections were still undecided weeks later after Election Day. Delays like these lead to uncertainty around our election process that ultimately undermines the public trust. Additionally, in New York, we saw the voters in 2021 reject our COVID emergency voting measures, such as automatic no-excuse absentee voting without the need for a Social Security number or even a photo ID. However, the legislature decided to overrule the will of the voters in a public referendum and make them permanent anyway. In these types of bad policies, it makes it close to impossible for election officials to weed out fraud. They also play an enormous burden on local boards of elections, leading events to, like my own 2020 congressional race, which tied up the courts for months, leaving my constituents without a voice in Congress until I was ultimately sworn in February of 2021. Voting is one of our most sacred rights as citizens of a self-governing constitutional republic. I'm honored to be joining you here today to discuss how we can restore faith and confidence in our elections. Our system is built on the public trust that the vote of each voting citizen will be counted, and we must assure the American people that we take this trust seriously. So my first question is to my fellow New York friend, New Yorker and lawyer and former elections official, Joe Burns. You witnessed the defeat of these propositions concerning elections in November 2021, and decisively. One proposed change to the redistricting process. One would have permitted same-day voter registration. The other would have established no-excuse absentee voting. As of February 2023, New York has over 13,554,876 registered voters, with almost half of those voters registered as Democrats, which means the Democrats have a 2-to-1 advantage, but overwhelmingly defeated all those initiatives that are being promoted by Democrats nationwide. Same-day registration and no-excuse absentee voting are two election administration processes widely supported by the left and touted as critical components to increasing voter turnout. In your opinion, why did the voters of New York reject a measure that many Democrats support? I know you have specific expertise in this field as a former election official.
Yes, thank you. As you said, all three of those proposals that were put forward by a Democratic-controlled legislature were defeated in 2021. Maybe more importantly, certainly statewide, New York is a very Democratic state, statewide, but if you look at the county level data, you see that these proposals were defeated in some of the more Democratic counties of the state. Wasn't simply the wasn't simply the rural counties, the more Republican counties. But I think when you get down to it, when these proposals were put forward to the voters of the state, regardless of party, when they had an opportunity to have their voices heard on it, on these proposals, they decided that they didn't want no-fault absentee voting. They didn't want same-day voter registration. And they wanted to keep the anti-gerrymandering provisions in the state constitution.
Well, let me ask you, because no-excuse absentee voting, or with excuse absentee voting has been on the books for a long time. Has it negatively impacted turnout in New York?
It's interesting if you look at the recent history in election results. I'll take the 2022 gubernatorial race and the 2018 gubernatorial race. After the 2018 elections, when you had this expansion of voting, when you had this expansion of absentee balloting, when you had this expansion of early voting, in 2018, you had over 6 million voters, New Yorkers, vote in the gubernatorial election. After these expansions took place, such as early voting, in the 22 gubernatorial election, you actually had fewer voters turn out, 5.9 million. So even with
Thank
that,
you. I think my time's expired. I appreciate it. Thank you to all the witnesses, and thank you, Mr. Burns.
Thank you, Ms. Tenney. I'll now recognize Chairman Stile for the purpose of questioning our witnesses.
Thank you, Chair Lee, for hosting today's hearing. Thank you to our witnesses for being here. America's decentralized election system is essential for our democracy. State, county, municipal offices who administer elections are best positioned to understand the needs of voters in their communities and are vested in the integrity of our election process and outcomes. As chairman, I'm committed to upholding our federalist approach by equipping states with the tools they need to make it easy to vote and hard to cheat. This means ensuring all eligible Americans who want to participate have the opportunity to cast a ballot and have confidence those ballots will be counted according to law. But it also means ensuring non-citizens are not able to cast ballots, which dilutes American citizens' votes. When voters are more confident their ballot will count and not be canceled out by someone else's ballots, they're more likely to participate. We see the data time and time again on that. Today, we're focusing on the American Confidence in Elections Act's provisions that ensure all eligible Americans are able to participate, in particular while preventing foreign interference. While non-citizens are already prohibited from voting in federal elections, some states and territories allow non-citizens to vote outside of federal elections. For example, in Washington, D.C., the District of Columbia now allows non-citizens to vote, and this would include embassy staff of countries like Russia and China after living in the country for just 30 days. I think this is a serious vulnerability to potentially nefarious foreign interference in our election and raises some pretty serious questions. The ACE Act will provide states with the necessary tools to prevent non-citizens from voting. We must equip states with tools to ensure elections are safe and secure while ensuring access for all eligible American voters. It should be common sense that only Americans should be able to vote in American elections. I appreciate our witnesses being here. I want to do two sets of questions if I can. If I can start with you, Ms. Dixon. Appreciate you being here. Rough math, do you know how many people vote in a Washington, D.C. election in a presidential year?
I actually don't know.
Total, rough math, we'll go 300,000. There's 8 city council wards in the District of Columbia. So if you break that down, it's roughly 40,000 votes per ward in D.C. Do you know how many non-citizens would be eligible to, or are eligible to vote in the District of Columbia following their change of law?
I would imagine it's a substantial number.
It's 50,000. That's actually in your testimony. 50,000 non-citizens in Washington, D.C. would be eligible to vote, which would clearly be enough if they're concentrated in any given ward, which would be rational to think, knowing that the embassies are located in a tight geographic area. Do you know how they'd be prevented from voting? They'd be allowed to vote in the municipal election, but then being prevented from voting in the presidential election?
We just have to trust that they're going to do that through proper procedures, but it creates a lot of administrative hassles for the election officials.
Does that increase confidence, do you think, in American citizens who are voting in the federal elections?
Probably not.
Let me shift gears slightly to you, if I can, Mr. Burns. And appreciate you being here and the work that you do on election integrity. In December 2021, the New York City Council passed a measure that will allow more than 800,000 non-citizens to vote in New York City local elections, similar to what Washington, D.C. passed. Except in New York, it was challenged and struck down by the state Supreme Court judge, citing that the law violates the New York Constitution, and now that case is currently on appeal. Do you support the state Supreme Court's decision?
I think I think the trial judge, the Supreme Court judge, made the correct decision on the non-citizen voting law.
If you could do it concisely, how would you note that it violates the New York State Constitution?
It's pretty clear to me, and I think it was pretty clear to the judge and most other folks who looked at this, that the state constitution is pretty specific that only citizens are entitled to vote, even in municipal elections, which of course this law applied to.
And let's just run the hypothetical that case doesn't come down in the way that you and I would like, and it plays out that non-citizens are going to vote in New York City municipal elections. Is there a concern citizens living in the 5 boroughs could vote in federal elections. Non-citizens, could vote in the 5 boroughs that could vote in federal elections. And how would you prevent them from voting in federal elections? Meaning, they're going to be on the roll. They could vote in municipal elections if this court case got flipped back and the law was allowed to move forward. How would you prevent them from then voting in federal elections?
I think it would certainly be very difficult, and I wouldn't envy the men and women at the New York City Board of Elections or any of the borough boards of elections. I suppose they would have to have 2 different sets of lists, one that would be simply for municipal elections, one that would be for state and federal elections. It certainly wouldn't be easy to do. I do believe that, I am confident that the Second Department, our intermediate appellate court, will find that the law is struck down.
Do you appreciate that? Do you believe that non-citizen voting dilutes the votes of U.S. citizens?
Undoubtedly, no question about it.
I appreciate you being here, appreciate your testimony. Madam Chair, I yield back.
Thank you, Chairman Stile. I now recognize myself for the purpose of questioning our witnesses. And I'd like to go back to you, Mr. Hearn, and specifically the Carter-Baker Commission, your role there, and some of the recommendations that came to us from that report. Could you share with us more about the Commission's recommendations specifically as it relates to voter ID and voter list maintenance?
Right. Thank you, Madam Chairman. Yes, my role was an attorney advisor. I worked primarily with President Carter as well as Secretary of State Baker and the other members of the committee in formulating and writing the report. We heard testimony at 3 different occasions from witnesses, expert witnesses, election administrators, trying to determine, if you will, recommendations that the committee could make to the states for best practices. And a number of those, and there was, again, a bipartisan consensus on these points of the committee. You mentioned photo ID. That was a big recommendation that the Carter-Baker Committee made. And the point that I think is, and I echoed this in some of my opening remarks, the point that I think it merits noting is that that recommendation was in the Marion County Crawford case. The Supreme Court specifically referred back to the Carter-Baker Commission and quoted them and their recommendation when they found that Indiana's voter ID law was constitutional. And as to the questions about citizenship, that is also a recommendation of the Carter-Baker Commission, that the ID affirm that the person who's presenting themselves to cast a ballot is in fact not just eligible, but eligible and a citizen of the United States. The other recommendations they made, which are particularly timely, are those about ballot harvesting and the prohibition on anybody handling ballots or collecting ballots or paying by the ballot to collect them and put them in drop boxes. That comes straight out of the Carter-Baker Commission. Again, that's a bipartisan recommendation. Jimmy Carter, when he testified, or didn't testify, but in speaking with him, his first Georgia State Senate race would have a lot of vote fraud in it. And that's why he became personally very interested in this. He went to one polling place afterwards and found that everybody had voted alphabetically when they looked at who voted in what order. And so it was clear that there was a concern about vote fraud of people coming in, and particularly with absentee ballots or mail-in ballots. And so the recommendation was that they not have that. And finally, we've talked about the current accurate voter rolls and the recommendation that those be uniform and that they be current.
Now, Mr. Hearn, on the subject of voter ID, I know we've had a series of hearings already on elections, and one thing that's become apparent from the hearing is that I believe there's actually broad consensus on both sides of the aisle that some form of ID is appropriate and important. Can you share your perspective on different types of ID, and if certain types of ID you believe are more effective or preferable to others in the context of voting?
So the recommendation the Carter-Baker made, and it was also what was litigated in the case that I handled for the state of Virginia that was upheld by the Fourth Circuit, was the recommendation or the requirement of government-issued photo ID with a identification of the voter. And again, you have measures to make sure if one individual does not have access to that, that it's given to them for free. They found in the Virginia case that following, again, the Carter-Baker recommendation regulations. The Commonwealth adopted photo ID requirement, but again, you don't have a requirement that say a Social Security card with no photo on it would work, or you don't have a school ID that doesn't have a photo, that's not a government-issued school ID. So those kind of IDs are not the ones that meet the requirements of the best practices that the Carter-Baker Commission recommended.
Thank you, Mr. Hearn. I'd like to thank everyone for participating in today's hearing. While we may have, I did not. You don't have a, no? All right. Good. Well, we may have some differences in opinion on the best path forward. It is clear that both sides of the aisle in this committee have these shared goals of increasing voter participation and improving voters' experiences on Election Day. I look forward to continuing the discussion on how we can boost voter confidence in the electoral process and outcomes and bring forward policy solutions like the American Confidence in Elections Act to ensure every eligible American has the opportunity to cast their ballot and trust that it will count. Members of the subcommittee may have additional questions for our witnesses, and we ask that you please respond to those questions in writing. Without objection, each member will have 5 legislative days to insert additional material into the record or to revise or extend their remarks. If there is no further business, I thank the members for their participation, and without objection, the committee stands adjourned.
All right. The Committee on House Administration will come to order. I note that a quorum is present. Without objection, the chair may declare recess at any time. Thank you, Ranking Member Morelli and members of the committee for meeting today to adopt Committee Resolution 11816. As noted, Committee Resolution 11816 adopts regulations regarding mandatory completion of a program of training in workplace rights and responsibilities. Without objection, the resolution is considered as read and open for amendment at any point. Does any member wish to be recognized? If not, I'll move the Committee Resolution 11816 be adopted. All those in favor say aye. Aye. All those opposed, no. The ayes have it, and the resolution is adopted. Without objection, the motion to reconsider is laid on the table. This concludes the order of business for today's business meeting. Each member will have 5 legislative days to insert additional materials into the record, or revise and extend their remarks. If there's no further business, I want to thank the members for their participation. Without objection, the committee stands adjourned.